Thanks, Allison. Thanks, everybody, for listening in. There's lots to talk about, so I'll say that when we're done, you can feel free to reach out. I think we've got a handout. You can have a copy of the notes. This is an ever-changing situation. And so we're going to talk about the antitrust lawsuits. There's more every day, but I'll talk specifically about 4 of them for you and give you some background. And the subject is there's an opportunity here. And the opportunity is everybody's heard about this. And because everybody's heard about this, they're going to have questions about it. And so it behooves you to know about it, to be able to talk to customers, buyers, and sellers about this, to be knowledgeable. It'll help you build trust and confidence in relationships. And it's important that you just keep doing things pretty much the way you're doing it, with a couple of small exceptions, and wait for this to kind of shake out. But it is big news. It's got the potential to dramatically change the way people do business in real estate. We don't know exactly when or how, but it's better to be prepared. I always say it's better to see the cliff well in advance. And so as we go through this today, I think we'll be able to give you some insight into exactly what's taking place. So you heard about probably this case in Missouri, Sitzer Burnett versus the National Association of Realtors and major franchisors. And so it was a big case, and the decision was a judgment where the damages were approximately $1.78 billion. And because it's an antitrust case, they're tripled, and that makes the damages about $5 billion. And that's a huge amount of money. And so that's against the National Association of Realtors, against Keller Williams, against Anywhere, which is the old Realogy, against, I think, Home Services of America, these major companies, $5 billion. So that's one suit. And that's the one everybody's heard about. That's all the buzz. And I just wanted to kind of get that out of the way, and we'll come back to that. And what we're really talking about are 3 civil lawsuits. And that's the first point, is that we're talking about civil litigation. Now, there's also one that's the Department of Justice against the National Association of Realtors. And that's a huge case, but that's not the one that's getting everybody's attention right now. The ones that are getting everybody's attention are these civil suits, and they are antitrust lawsuits, and they're class action. So important points: class action, civil litigation, possibility of triple damages. The first one has already been to trial, and we went over the judgment, $1.78 billion tripled to 5. There's a bigger case. So the big case was really Moehlr, Moehlr, and I'm going to keep repeating these things because I think it's important that you be able to talk about it, because there's not really that much. It's really very, very much a funnel, right? A tunnel. So if we got the basics, and as things get added to it, it'll be real easy to add on to it. So 3 lawsuits, civil litigation, antitrust, and they are Moehlr, that's in Illinois. And what's being attacked is the offer of compensation in the MLS. So it's important to understand MLS. And so there are a number of different ways to formulate multiple listing services, and most of them are formulated and act under the guidance of something called the National Association of Realtors MLS Handbook. Now, the National Association of Realtors, and this is very important, does not have an MLS. Doesn't have an MLS. But the National Association of Realtors kind of like has created best practices for multiple listing services. And if you are a realtor-owned MLS and you follow the best practices, the MLS Handbook, which, by the way, is available to you if you're a realtor, you can go to nar.realtor, and log in, and you can download a copy of the MLS handbook and learn about and read about MLSs. And that's important because the MLS is probably your most important tool when you sell residential real estate. And so the National Association of Realtors has these rules. And if you follow these rules, then you're covered. Your MLS is covered by the errors and omission insurance of the National Association of Realtors. So, of course, just about all realtor MLSs, which are typically owned by local associations of realtors, or they are regional, owned by a number of local associations of realtors. There are also broker-owned MLSs. And MLSs function typically as either a committee of their association, or as a wholly owned subsidiary, or as a regional. And again, if they're realtor MLSs, then they follow this guideline of the National Association of Realtors. And so every one of the things that makes MLS work is that there is what I refer to as a compensation vehicle. So MLS has a compensation vehicle. And I was first licensed to sell real estate in 1975 in California, got a broker's license in 1977. And I joined the MLS, and the compensation vehicle in the MLS, and some of you might remember this, was a unilateral offer of subagency. A unilateral, I won't ask you to raise your hands, but I can tell that some of you remember this, right? That the MLS was a unilateral offer of subagency. And what that meant, and we didn't always know why, but what it meant was everybody represented the seller. Everybody represented the seller. And so if you took a listing and you put it into the MLS, all of the other participants and subscribers of the MLS, they could represent the seller as you represented the seller. They were really subagents. And so the compensation was easily flowed because the compensation vehicle was this offer of subagency. Everybody represented the seller. There was no beef about the seller paying the commission to both parties because both parties represented the seller. And that was the unilateral offer of subagency. And that worked. Now, here's the deal. We didn't have to tell buyers that they weren't represented. So we all represented the seller. There was no law that said we had to explain to sellers or buyers that we represented the seller. We were cautioned not to call buyers clients. Our attorneys said, no, you call your buyers customers, call your sellers clients. And the reason they were clients is you had a fiduciary duty to them. Everybody represented the seller. Well, the Federal Trade Commission in 1983, and this is an important document if you haven't seen it to read, it's on the internet in a number of places. You can find it on our website on thedataadvocate.com under resources. And it is a 1983 study of the residential real estate industry. And it kind of laid out a number of things. And one of them was that buyers weren't represented and didn't even know they weren't represented. And so there was a movement to inform buyers and sellers of representation in real estate transactions. And the first state to pass agency disclosure laws was California. And so we passed agency disclosure in California in 1986. We had like 15 months to get ready to start to use the forms created by the legislature. Now, you might not know this, but there were actually 3 bills on the floor of the legislature at that time to kind of control agency in real estate. And one of those wanted to make dual agency a criminal offense. And so there was this push to outlaw dual agency. And so what happened was the California Association of Realtors was very active in lobbying the legislature in California at the time. And what we ended up with was a compromise. And the compromise was that you could still practice dual agency, but you had to disclose to a buyer or seller who you represented in a real estate transaction. And that's the case today, isn't it? After you establish more than a casual relationship with a buyer or seller, you got to sign this agency disclosure form.